फ्रेंड्स, आज की क्लास में मैं आपको लीगल डिक्टेशन दूंगा 100 WPM पर। ये उन लोगों के लिए ज़्यादा बेनिफिशियल होगी जो दिल्ली डिस्ट्रिक्ट कोर्ट PA एग्ज़ाम के स्किल टेस्ट की प्रिपरेशन कर रहे हैं। बी रेडी, 3 seconds लेफ्ट। स्टार्ट। ऑन 18/3/2019 an incident took place by which the son of the claimant, who allegedly was a pillion rider, was killed in a road accident. The Motor Accident Claims Tribunal, Dehradun, hereinafter referred to as MACT, after examining the evidence, came to the conclusion that the accident was due to the rash and negligence driving of respondent number 2, who was the owner of the motor vehicle and who was driving the aforesaid motor vehicle. The victim was aged 28 years, coming to the conclusion that a salary of rupees 3,000 per month would be adequate with a deduction of 1/3 and taking the multiplier as 8 dependent upon the claimant's age, the MACT finally held the insurance company liable to pay a total of rupees 1.99 lakhs plus 6% one civil appeal number 2527 of 2020 interest thereon. In the appeal filed before the High Court of Uttarakhand by the impugned order dated 28/12/2018, the High Court held that since the insurance company denied that the deceased was only a pillion rider and stated that he was in fact driving the vehicle himself, also since the claimant was not present at the spot, and since Shri Virendra Dijalwan, respondent number 2, who ought to have been called as he was the only surviving eyewitness, not being called as a witness, therefore proved fatal to the claim, as a result of which the petition under section 163A of the Motor Vehicles Act 1988 would have to be dismissed. Further, the High Court also held that nothing was brought on record to show that the deceased was having a valid driving license. In this view of the matter, the appeal was allowed and the judgment passed by the MACT was set aside. Shri N.K. Sahu, Learned Counsel, appearing on behalf of the petitioner, has argued that the petition being filed under section 163A, it is clear that the liability is no fault, as a result of which it is not necessary to prove the negligence or any rash and negligent driving on the part of the driver of the vehicle. He further argued that the multiplier of 8 is ex facie incorrect, since it was taken on the basis of the claimant's age and not the victim's age, stating that since the victim was only 28 years old, the 2 civil appeal number 2527 of 2020 multiplier should have been 17. He also argued that the High Court was wrong in placing the burden on the claimant when MACT has held that based on the examination and cross-examination of the claimant, the facts could be elicited. Further, the validity of the driving license under issues number 2 and 3 was given up by the insurance company but taken into account by the High Court. Shri Anshuman Jain, learned counsel appearing on behalf of the insurance company, reiterated the High Court's judgment and further argued that no fault liability under section 163A is limited to rupees 1 lakh. At the relevant time, therefore, even if we were to uphold the max judgment, the maximum can be awarded on the facts of this case is rupees 1 lakh.